Good afternoon, everybody. I'm Jessica Linder-Gallo, President and CEO for the Aurora Regional Chamber of Commerce. Thanks so much for joining us today for our second webinar during coronavirus here. So on today's webinar, I just want to let everyone know we do have on the line both members of the Chamber and folks who are not currently Chamber members. So for those not currently Chamber members, I just want to give you a little bit of background on the Aurora Regional Chamber of Commerce. So we're an association of businesses throughout the greater Aurora and Fox Valley region. We represent nearly 600 businesses in the region, and those span all sizes from one individual person to hundreds of employees, and all sectors from retail and restaurants to B2B service providers and manufacturing logistics enterprises. Our mission is to be a catalyst for business success, and especially right now during this very critical time we're all navigating, we are happy to be here to help all businesses throughout this. So today we're here to talk about the Family First Coronavirus Response Act and the CARES Act. Hopefully you know that and didn't find yourself in the wrong Zoom meeting. If you did, now's your chance to jump off here. But we hope that you've come to the right place. This is part of our Impact to Employers series that we run throughout the year, bringing you topics that are relevant. We'll be talking about the requirements for employers and resources that you can be accessing during this time. I'll be moderating today's webinar for us. I just want to go through a couple housekeeping items as we get started. So you'll likely notice that your video is turned off and all attendees have been muted just to make for the best experience as we hear from our presenters today. Please note that today's webinar is being recorded, which you'll receive after the webinar is over. So with us to talk through the Family First Coronavirus Response Act and the CARES Act are Julie Proscia and Rebecca Dobbs Bush from SmithAmundsen. Julie is a partner with SmithAmundsen out of St. Charles, Illinois. She provides labor and employment counsel that is outcome-based. Julie works with private sector businesses of all shapes and sizes, public entities and municipalities, and non-for-profit corporations. In 2012, Julie was honored as one of the 40 attorneys under 40 in the state of Illinois to watch by Chicago Lawyer magazine. She was elected to the Illinois Super Lawyers Rising Stars list in 2011, 2013, and 2014. Soon followed by her selection to the Illinois Super Lawyers list, which she's been consecutively named to from 2015 to 2020. Prior to joining SmithAmundsen, Julie practiced at a Midwest-based boutique labor and employment firm. Preceding that, she worked in human resources at Northern Illinois University as the Assistant Director of Affirmative Action and Legal Compliance. Rebecca Dobbs Bush is also a partner with SmithAmundsen's Labor and Employment Practice Group. She's based out of Milwaukee, Wisconsin. As a former human resources consultant that worked with a variety of businesses in different industries, Rebecca has a unique understanding of the legal landmines that her clients face every day. She focuses her practice on employee benefit compliance, administration, and litigation, including COBRA and HIPAA compliance, deferred compensation plans, ERISA fiduciary obligations, and ERISA litigation. Rebecca was selected to the Illinois Super Lawyers list of Rising Stars consecutively from 2013 to 2017. Really excited to be joined by these ladies today who, if you can't tell, know their stuff and have a lot of great information for you today. We'll be sending both of their full bios to you after this webinar with their contact info so that you'll have that as well. And after Rebecca and Julie present, we will open it up for Q&A today. So as we go through the presentation, feel free to drop any questions you have in that chat box. I'll be keeping an eye on those and combining similar questions as needed for afterwards. But with that, Julie, Rebecca, I'll go ahead and hand the reins to you.
Well, thank you so much. It is a pleasure to speak to everyone today. I know that this is a very, very challenging time for all businesses. We have, not speaking for Rebecca, but like we have been crazy busy over the past few weeks navigating the situation as well with our clients and trying to be able to assist you guys with the ever-changing regulations that are coming out and with the contradictory regulations that are coming out. So that's what we're going to be doing today, is we're going to help you navigate through the FFCRA as well as the CARES Act. And there we go. So starting off, we're going to talk, I'm going to start off with the FFCRA, and then Rebecca's going to jump in with the CARES Act because she is a tax ERISA guru, and I am going to have her round that off and end with all of that. So what we're going to be talking about today is the FFCRA, the Family First Coronavirus Response Act, and in particular, in that we're going to be looking as well at the Paycheck Protection Program that's under CARES, the payroll tax credits, the loan unemployment benefits, and hardship loans, as well as the qualified disaster payments. And this is, as I said before, this is a really dynamic situation because what came out the first day was different than what came out the second day, which was came out the third day. So you might be like, well, I already heard some of this. Well, it has changed dramatically from 1 hour to the next. So when we're talking about the Families First Coronavirus Act, the FFCRA, we're focusing on three main things: the paid leave component, the expansion of the FMLA, and the expansion of unemployment benefits. And when we're looking at that, we're going to start off with who's eligible, right? So which employers are subject to the FFCRA. And when we're looking at that, it is employers that have less than 500 employees. So that's what you start off. That's your big start off, is employers that have less than 500 employees and government employers. Now there are exemptions, right? So the exemptions are for things like healthcare providers and for first care responders. And healthcare providers is now pretty broad. When it was initially put in there, it was fairly small. But now it includes things like homes for individuals with developmental disabilities, as well as, you know, what you would traditionally think of as hospitals. There is also an exemption, or an exemption that people can try to apply to for businesses with under 50 employers if giving the FFCRA would impinge on the economic viability of the business. So I'll talk about this a little bit more later, but we're just going to start off with, it is virtually impossible to, I think, you know, correct me if I'm wrong, Rebecca, to be able to qualify for this exemption, because you have to essentially show that if you gave 2 weeks of paid sick leave, of which you are getting a tax credit for at the end of the quarter, that would destroy your business. That's a really hard bar to go on. So when we're looking at the paid sick leave component of it, the paid sick leave component of it is essentially paid sick leave for up to 2 weeks off for up to 80 hours for full-time employees, or the average number of hours that a part-time employee would have worked for a 2-week period for individuals who are either exhibiting symptoms of coronavirus, of COVID-19, or a variety of other factors. And I'm going to go through those factors. This is a one-time usage. So this is a 2 weeks, 80 hours for one time. This leave is added to any paid leave that they already have that's required by state law. And it can also be added to any additional leave that they have. So it doesn't mean like if you take this, then they can't take vacation or their sick leave. Most of this leave can be used intermittently if an employer designates it. And the reason that I'm saying that most of this leave is because it's going to depend on what type of leave it is. So these are the 6 key components of what you could use the FFCRA, the paid sick leave, for: the up to 2 weeks off, the up to 80 hours or the equivalent thereof if you are a part-time employee. The first one is subject to a government directive or quarantine or isolation order that includes a stay-at-home order. So think of this as if you are not designated as a essential business, like a restaurant, and you've been subject to the directive that you have to stay home in Illinois, then that would move under 1. So you would qualify or be eligible for the 2 weeks of the paid sick leave. You've been advised by a medical care provider to self-quarantine, number 2, because you have COVID, you're experiencing COVID-19 symptoms. You're experiencing COVID-19 symptoms and you're seeking a diagnosis. You've called into the telehealth physician. You're caring for a family or household member that's subject to a quarantine order. So they're experiencing COVID-19 symptoms. They have been diagnosed. You're caring for a child with closed schools or where no caregiver is available due to the medical emergency. So school's closed, their daycare is closed, you've got the child at home. And then other reasons as directed by the HHS. So when this initially came out, everybody was like, what does that mean? And then subsequent to that, FAQs came out. And what it really is it's the catch-all. And it's been used as the catch-all for things like a medical professional has opined that you are in a high-risk category, whether it's age or a medical a medical issue that you have, so they're advising that you stay home. That would fall under the number 6, other reasons as directed by the HHS.
Julie, I want to clarify something with you, because I've had this question come up with clients, and this is how I think, we're all interpreting it at this point, given the guidance. But when the first sentence is saying employees unable to work at home or remotely because the way it's worded, like, for example, if you have somebody who's directed to stay at home by a medical provider and say, you're high risk, you should stay at home, but the employer has telework available and you can do the telework from home, you can't just say, well, I don't want it. I want to just get my paid leave, right?
That is a really good point. So it has to be that they can't also do remote work. Now, when I was talking before about how, it could be intermittent, the employer can designate whether they want to do it intermittently. And for most of these, the ones that it can't is, well, you can't intermittently come into work if you've been diagnosed with COVID-19 or you're experiencing symptoms. We don't want you in the shop, so we don't want you to come in. But if you are taking care of your kid and you're homeschooling for 3 hours a day, and then you could do it after that, and you're working remotely, then you can do it. You could do so for intermittent if that works for you as an employer. You could designate that. So it's the logical. Think of it as if somebody's sick, you can't have them come in. But if they're caring for somebody at home and they have remote work for them, you can have them work remotely if they would like to do so, because they would be able to do so. They would be able to intermittently work. So how do we figure this out? So they get the 2 weeks or up to 2 weeks, depending upon if they're part-time or full-time. When we're figuring out how much they would make, we're looking at their regular rate of pay, their average pay, including everything, overtime, tips, commissions, of what they would have made in a 2-week period. If there's somebody who just started, it's what would they have estimated to have been making in that 2-week period. And that's what we're going to do, and we're going to break that down for it. So when we're looking at 1, 2, and 3, and I know I don't have it up, but so 1, 2, and 3 is they're under the government isolation order or quarantine. Think of your restaurant, where they don't have anything to do, where they can't go in. They've been advised to self-quarantine because of COVID-19 symptoms, or they're experiencing COVID-19 symptoms. Those individuals are eligible for their regular rate of pay up to $511 a day, or for a total of $5,110 for the 2-week period. If it's 4, 5, and 6, they're caring for an individual who's subject to a quarantine order. They're caring for kids, or that catch-all category. Think of it as I'm in a high-risk category, so I'm told to stay home. There's no work for me to do remotely. Those ones are their regular rate of pay up to $200 a day and $2,000 total. So think of it as the first block is individuals who are ill, and the second block is individuals who are caring for children or other individuals, and when you're denoting how you're going to do it. When this initially came out, we were getting flooded. I mean, you could just stop with a end stop, but we were getting flooded with calls. But in particular, we were getting flooded with calls of well, what are we supposed to be collecting? How are we supposed to know what we're supposed to be grabbing and everything? And what type of documents? And there was a lot of supposition. And really what it came down to, and this is one of those times where the FAQs was different than the guidance that came out later on, is that we don't need a doctor's note. Why don't we need a doctor's note? Because in places like New York, you're not going to see the doctor. In most places, particularly urban areas, and we happen to fall in that, right? What doctors are saying is call the telehealth, and the telehealth or your physician will say, we're telling you not to come in, but they don't have the time to give the notes. So what we're saying is, and what the guidance says is that individuals just need to give you a written request with their signature, identifying the reason for the request. I've been advised for a healthcare provider to self-quarantine because I've been diagnosed with COVID-19. Here's the name of my healthcare provider and their contact information. And that's what we would use as our backup documentation when we're looking at our taxes. It's also what we would use if later on we felt like the individual was not above bar, and we thought that there was any type of concern regarding the veracity of what they said. Then we would contact the individual's physician or medical provider for additional information. For the child care provider with the school closure, so it's that the order that schools are closed. Well, you know, that was all over the news that you could do a quick print download from J.B. Pritzker. The same thing where it is or any other governor from any other state, says all 50 states are under a lockdown now, as well as the request. You know, my child's school is closed, requesting the leave, and the name of the child care provider, if the child care provider is closed, and their contact information. And that's really what you need. That's one component of it. So there were two components under FFCRA for purposes of leave. The first is the paid leave. That's the 2 weeks, right, that we talked about. And those individuals are eligible on day one if they've only worked for you for a day. And the reason that this was put forth is they don't want people to come to work if they're sick. And the whole purpose of this leave is so that people won't gut through. In this country, we have a very strong sentiment of, I'm just going to do my job. And because of the community transmission, we don't want people to just suck it up and do their job because they're diligent employees for you. We want them to stay home. And this was giving them the cushion so that they could stay home. The second component of it is an expanded version of FMLA for longer than when somebody is ill, essentially. And so this is applicable to, again, employers with 500 and less employees and government employees, and it has the same exemptions where a healthcare provider or and first responders and businesses who could qualify for the economic viability exemption can try and exempt out. So one thing I didn't say before is that just because you can qualify for the exemption doesn't mean that you have to take the exemption for your whole workforce. So like, I know that a lot of, like, let's say hospitals are taking it for their medical staff because they need their medical staff not to take an expanded FMLA for an additional 10 weeks or for 10 weeks, but they're individuals who work in the administrative offices they're granting it to. So they're exempting it out in part. So who's eligible? So for the 2 weeks of paid leave, the sick leave, that was everybody. Day one, you walk in the door, you filled out your I-9, you are eligible. For the expanded FMLA, that is for individuals who have been employed by you for 30 days, 30 calendar days at least. So what is this? So this is a little bit different than the paid sick leave. So this is an additional 10 weeks. And so it's up to 12 weeks if you wrap in the paid sick leave. It's not 10 weeks and 2 weeks and 12 weeks. It's a total of 12 weeks a person can take. For this component of it, you can only take this if you are caring for a child who's under the age of 18, if their schools are closed, or if their child care provider is unavailable due to COVID-19. So I want to clarify a couple different things. One is, even though the regs say that it's for caring for a child under the age of 18, the subsequent guidance expanded upon that to say that if you have a child who is developmentally disabled, physically disabled, who you are the caregiver for, who's over the age of 18, that you would still fall under this. So that 18 mark is not necessarily a cut and dry 18 mark. So you would get, this is how this would work. You would get, if you applied and you were eligible, 2 weeks of the paid sick leave to care for a child, right? And that would be at the 2/3 rate of pay, up to $200 a day for that total of $2,000. And then after that, you could apply for an additional 10 weeks, and that would be the same thing, 2/3 rate of pay, up to $200 a day, and that would be for a total of $10,000. So I only have the 2,000 on there, but that would be for a total of up to $10,000. So in total, an individual can get 12 weeks. This is not in addition to regular FMLA. So you couldn't get 12 weeks of this and then 12 weeks of FMLA. You get 12 weeks total. And this is different than regular FMLA because the FFCRA expanded FMLA for childcare wouldn't have qualified under regular FMLA because regular FMLA is for a serious health condition for yourself or for your member of your immediate family to take care of yourself. So this is separate. And this component of it, the expanded FMLA, allows you to get the reimbursement, the tax credit. That is not the case with regular FMLA. So if somebody is sick, they come down with COVID-19 and they are very ill, they would get the 2 weeks of paid leave under the Paid Sick Leave Act. And then if you are a eligible employer for FMLA, you are an employer with 50 or more employees, they could take another 10 weeks off under the protection of FMLA, but you wouldn't get the credit for it, and it wouldn't, and they don't get reimbursement for it. So it's separate. This expanded component is only for individuals that are caring for a child. When we're looking at both the paid leave and the expanded FMLA leave component of the FFCRA, this became effective as of April 1 of 2020. And that means that individuals who were ill or had a qualifying event, you know, they're experiencing symptoms of COVID, childcare, they've been given a note by their physician that they're in a high-risk category, that could go back to April 1 of 2020. Anything that happened before that wouldn't be retroactive for purposes of the paid leave and the expanded paid leave component. Employers are required to give a notice to all of their employees regarding this leave. And that notice, and we could send that to you guys if you want it, and we can link it to the chamber as well, is from the Department of Labor. And most of the time, in a normal circumstance, which we get, this is not a normal circumstance, you would post it in your break room. Well, we don't want people congregating in the break room, and and a lot of times people are working remotely. So while we will still post it in the break room, if individuals are remote, we would either send it to them via email, or we have a internal website intranet that we post the rest of our policies. That's where it's going to go. For both the paid sick leave component of it as well as the expanded FMLA component of it, there's no retaliation for requesting the leave. Meaning, if somebody comes in and says, I don't feel well, I have COVID-like symptoms, I'm going to call the telehealth, I don't want to come in, we can't then fire them or threaten to fire them because they're taking the leave and requesting the leave, because that defeats the whole purpose of trying to stop the community transmission and the spread. So we want to make sure that what we're doing is that we are taking all of the documents that we're getting, the written signatures or the written notifications regarding the leave, and that we're keeping a file on that, and that we are in our systems, whether it's HRIS or whatever our payroll systems are, denoting that this individual took a leave under whatever, number 1, number 2, under the FFCRA, so that we get tax credit through this. Because at the end of the quarter, we could get 100% tax credit back or denoted on all these individuals who applied for the leave. So it comes down to, why would you not do this? Why would you not do this? Because you're getting the recoupment. So unemployment, this is the third component of the FFCRA. So, you know, as of today's date, there's about 17 million people, million Americans who have applied for unemployment. And so this is expanding unemployment. So it makes it back effective to January 27th of 2020 and through 12/31. And the eligibility is the same as the paid sick leave. You're caring for a child, you're experiencing COVID symptoms, you didn't, but it's also expanded because it's things like you were offered a job and you were supposed to start on March 30th, but what do you know? You can't start because the restaurant closed, because the airlines aren't running and your job was rescinded. You became the head of a household due to a death of the head of the household, or your resignation as a direct result of COVID-19. And when we think about that, that is, if it's something, that dovetails with the next one, the fear. So people who are just saying, I'm scared, so I'm resigning. I don't want to come into work. I'm scared, so I'm resigning. don't qualify for unemployment. But, big giant but caveat when I'm saying that, find out why they're saying they're scared, because they might now qualify and go back up to the resignation as a direct result of COVID-19 under that essentially other duties as assigned component, the catch-all category of the number 6 that I went through. Because what if they say, the reason that I'm scared to come in is that my wife is 9 months pregnant, she's had 4 miscarriages, and she's at a high risk, and I'm scared of the transmission. In that case, they likely will qualify, particularly if they call up a physician and they say, you know, you or your wife is in a high risk category, you're working in a supermarket, we don't want you to come in, you know, whatever it is. So we want to dig a little deeper into the I'm just scared. Also, under the stay-at-home orders and under the general duty clause, employers have an obligation. Just because you're essential doesn't mean you're essential, but you could just haphazardly open your business. You could be an essential business, but you still have to, under the stay-at-home orders in all of the states, do things like practice social distancing, ensure that there's hand sanitizer, ensure that the workplace is clean. If you get a positive diagnosis of COVID-19, ensure that the facility is clean. So if somebody says, I'm scared of contracting COVID-19, and the reason they say it is because they say our workplace is unsafe, we don't have masks, we don't have any type of social distancing, you're making us meet in a conference room with 10 people in a little room, you are likely not going to be able to successfully deny it. So just real quick, and then I know that Rebecca's going to jump on with CARES. It expands the unemployment for an additional 13 weeks at $600 per week, in addition to their regular unemployment. So individuals can qualify for additional money. There's no waiting period. I mean, there is kind of a waiting period. There's not supposed to be a waiting period, and you could get it retroactive back. But because 17 million people are applying, the phone lines are jammed, but there's no waiting period for when it could go back to. It also covers many more individuals, self-employed individuals, independent contractors, gig workers, even individuals who have been temporarily furloughed or laid off, and benefits for the most part are being extended. Their healthcare benefits under their plan, as long as it is a temporary benefit or a temporary layoff. We need to make sure that we check our states to see if, because different states have different programs for, you know, how much money will be expanded upon. Okay, last but not least is, this is my everybody take a deep breath. Everybody take a deep breath, because it has changed from 1 hour to the next to 1 day to the next. While things are still stabilizing, everybody's getting this wrong. We're getting it wrong. Everybody's getting it wrong, because what it will say today, they are saying something different tomorrow. So take a deep breath, and as long as it's not willful, as long as we're acting in good faith, we can remedy it, and it will be okay. And the DOL has said that in writing. We get it, unprecedented. We could remedy it. So I'm going to now switch it over to Rebecca, because she now has to, like magic lightning, talk about CARES, because I talked too long.
No, it's okay. I can cover, and you covered unemployment too, so we're good. Okay. So the first slide had said, talk to your bank, period. And the reason I wanted to mention that specifically, oh, can everyone hear me? Okay, just checking. Oh shoot, now sorry. Okay, because it changes based on, you know, banks, let's put it this way. The loan programs made available under CARES were optional, and they were all pushed, to the extent they're all pushed onto the bank to say, you know, hey, do you want to do this? And this is the program. But basically, the way the federal law was passed in an effort, presumably, to get the money to people quickly, is it was, okay, banks, you're going to distribute these billions of dollars to people, and, you know, we'll give you some guidance, hopefully, along the way. And so some banks had been burned after, you know, 2008, and a lot of the, you know, and SBA is also apparently notorious for not always following through on their guarantees. So there was a lot of hesitation on the part of banks in terms of, I don't trust that we're going to get reimbursed for this. We're going to give out all of our collateral and the SBA is going to say we got it wrong and not reimburse us for these loans we're giving out. But that said, they're working through the guidance. Most banks, if you have, because like Julie said, a lot of things are flip-flopped. I mean, I was on the phone with a client at 5:30 at night, or in the evening a couple weeks ago, and I kid you not, the second I got off the phone, I got the email with the updated regulations, updated guidance that changed the very calculations and flip-flopped them back. The statute said it one way, and then the SBA gave out certain guidance that contradicted it, and then the Treasury came out with guidance like 3 days later saying, never mind, use this calculation, and whatever you use that was in place at the time of your loan application is fine. So it's crazy town, all right? The banks don't know what they're doing. We're all getting through this, just like with the FFCRA, the best we can. So it's about due diligence, a reasonable interpretation of things. And at the end of the day, if your bank takes a different interpretation than mine, then guess who's going to win at the end of the day? Your bank, because they're holding the money and they're the ones that give it out. So, so what they want for documentation and what they're doing, and a lot of them are only working with existing customers. So you want to have that business relationship with a bank, and this isn't the time to start up a new relationship with a new bank. That said, if you don't have an existing business relationship, there's available money through, like, PayPal was just an approved lender through the SBA. There's some other online lenders like Cabbage, which I think is another small business processing loan payment person. So there's other options now that are slowly trickling out. But what I wanted to say is that how much can you get? $10 million or 2.5 times your average monthly payroll costs. That's a pretty big cap. And you're looking back, generally, there's a couple calculations, but to simplify it, most banks are saying, let's look back at 2019 and take the average and using that calculation. So what does this mean, payroll costs? That means, this is the one that's been flip-flopped here. Cash compensation to employees not in excess of $100,000 a year. So if somebody makes $150,000, you're taking off the 50. You're only looking at $100,000 for that particular individual, but you still get to count the employer contributions to a retirement plan. So if you're paying into a pension plan and making contributions, or if you're doing an employer match, that's covered. Then you also get to pay the, or consider the employer share of group health costs, including premiums, and the employer share of state and local taxes. So your unemployment taxes, for example, you cannot claim Social Med. Okay, my screen is not. Julie, can you flip it for me, please? Thank you. The other term is there are no personal guarantees, no collateral required, no requirement to show you can't get credit elsewhere, which is really a crazy thing that all these things were thrown aside. Most businesses don't have loans where their owners haven't had to personally guarantee and sign over their house and everything else. So it's a big deal. You know, where in some cases these loans are, you know, more desirable. I mean, I don't know why you wouldn't use it, especially when we get to the forgiveness aspect here in a second. Oh, yay. Okay. Shockingly surprised by technology and its cooperation all of a sudden. All right. So little things these days, right? So 100% forgiveness on these loans. Yes, 100% forgiveness. It's not a catch. It is 100% forgiveness if you spend it the way the government wants you to. One thing I want to point out is, you know, all of these loans and programs, it's no double dipping, okay? So think of it this way: unemployment, FFCRA leave, PPP loan money, all of this is designed to fund payroll for the average American. And the government is basically trying to step up and fund those paychecks, and they're doing it in one of those three ways in most cases. So if you have somebody that's getting FFCRA credit, you're not going to be able to claim that as a payroll expense and that you've spent it on that. But you know, it's one or the other. So if you spend it and on how the government wants you to, they will forgive the entire loan. That means the SBA will write your bank a check for your entire loan principal balance plus the 1% interest you've accrued over that initial 60 days, and you will be refunded, or I'm sorry, your bank will be refunded for everything they gave out to you and compensated. So what you want to do, if it's not forgiven, because forgiveness is not all or nothing, it's prorated. If it's not forgiven, the terms of the remaining balance, if you choose to keep the money, is a 2-year repayment term, 1% interest, no prepayment penalties. And again, remember, you haven't put up collateral for this money. You haven't personally guaranteed this money. If your business goes out of business, you're not giving up your house when this money isn't covered. So it's a big deal. That's why the banks are very hesitant, that they wanted to be confident, super confident the SBA was willing to back the money. What do you have to spend it on? You have to spend at least 75% of what you take out on payroll costs. Now, there's 2 factors here, because now I'm getting the calls of, I got my PPP loan money, what do I do with it? Right? I say, okay, let's do a ledger. We're going to keep track. However it is, like if your accountant already has this set up for you, that's great. If you're a smaller business and you don't have it figured out, that's, let's go to that. But basically you're getting total loan amount, principal amount. What's 75%? Putting that in one column, 25% putting in another column, and we're going to deduct off. So we know where the documentation is. Oh, I look like I have no arms with the green screen. Note to self, don't use hand gestures on Zoom. So you want to track how you're spending it and wind it down. So you're looking at 8 weeks of how you spend it. Now, the reason it's 75-25 is if you look back at loan avail maximum, it was 2.5 times your payroll costs. So they basically took 10 weeks of your payroll that they let you take out the loans for or get this money for, and then they're only looking at 8 weeks of how you spent it. So the other 25%, you're looking at any business loan interest, any mortgage interest, for it's business debt interest, it's business rents, it's utilities. It has to be an obligation or a service contract that was in place prior to February 15th, right? You can't take this and be like, woohoo, let's, buy all these different services now. Economic injury disaster loan, I'm not going to go over that too much because I personally think with the stage of the game we're in now, you're going to also, anybody that fits under this is going to be eligible for PPP loan money, and that money could run out. So your first step at this point is to be applying for PPP loan money. And again, back to the no double dipping theme, even if you had an EIDL, it gets rolled into the PPP loan money and refinanced. So it's not one or the other, and EIDL loans are not forgiven. So I don't know why you would choose that, but know that that's in the background in case you don't get to the PPP loan money before it runs out. Because the first 10,000 of the EIDL loan money, if you qualify based on some of these standards listed, is a grant, which means you don't have to pay it back. Okay, the employee retention tax credit. Again, it's a no double dipping, so you can't do these things and then still do PPP loan money. So I find that really this employee retention tax credit comes into play if PPP loan money is not ideal for you. In some cases, it's not ideal for you because you're not eligible, so then it's just not an option, right? You have more than 500 people. Or it's not ideal for you because you're not going to have, or there's a good chance you're not going to have 75% payroll costs to cover in the first 8 weeks. And in some cases, you don't want to resume payroll on everyone because they're maybe at a level where they're going to get more on unemployment, and they'd be like, thanks for nothing. I'm getting this great raise now sitting at home, and you're basically disqualifying me from it. But, so if you have more than 100 full-time equivalents, which is the second to last bullet, that's the one where, you might be using this employee retention tax credit, you're more than 500. But if you're more than 100 full-time equivalents, you want to note that the credit is only available for wages paid to an employee that is not providing services. If you're under 100 full-time equivalents, then you can use this to pay the credit, to get a credit for wages paid to any employee. But basically, it's if your receipts are down, they're 50% compared to the quarter in the prior year, and you get 50% of qualified wages per employee for the quarter, up to $10,000 per employee per quarter. Another option, again, can't do all of this if you're getting PPP loan money, but you basically, if you're not taking PPP loan money, maybe one option that you want to consider, another tool in your toolkit, is that, look, I'm going to take the availability of the option to not pay payroll taxes during the entire year of 2020. That's right. So you're saying, I'm not going to pay any of my payroll taxes. I'm going to defer them at 0 interest with 50% not due until December 31st of 2021. And then the second half not due until December 31st of 2022. So that'd be basically a no interest loan on your payroll taxes. Assistance for mid-sized business, and then you can flip to the next one, which maybe I have something on Main Street lending, but these are, oh no, go back, I'm sorry. These other programs, there's very little guidance. And a lot of people aren't using them, even if, you know, they're not eligible for CARES. The point is there's stuff out there, but those employers tend to not take advantage of them because there's too many strings tied to the money. It's no loan, and there's no loan forgiveness for it. And right now with the interest rates, you might be able to get something with lower than 2% interest. I mean, it's kind of crazy right now. And you can get deferment for 6 months on a lot of your existing debt obligations. So that's not a big deal either. But the bigger kicker here is that you have to remain neutral in any union organizing effort if you take this money for the next, for the duration of the loan when you're paying it back. And that's a big deal for businesses of 500 to 10,000 employees. Okay, next. We can do, I'm only going to say that the reason this is here, and I don't need to address it because Julie did, but basically the FFCRA started addressing unemployment and then CARES kind of wrapped it up. So, you know, she covered all of the unemployment issues when she discussed it with FFCRA. Okay, expanded 401k provisions. Here's another tool in your toolkit to help your employees because you really want to just get through this time together, right? So you have, if you have a 403b, 401k, or IRA right now, you can have hardship distributions that are going to be presumed to be COVID-19 related up to $100,000. The big deal is that there's no penalty for early distribution with the 10% excise tax not being imposed. It's also a big deal because you can include those in income for 3 years with the you can stretch out your tax on that distribution over the next 3 years. So if your account's tanking, for example, and you got a ton of money socked away in there, and maybe they cut wages or they did other things at your work, and you had to cut wages for the employees and stuff, you know, this could be a tool that is helpful to them. So they look and their account's dwindling, right? It keeps making negatives. So I'm going to pull out $100,000, and at the end of the year, I can just pay tax on $33,000. If I don't use the other $66,000, what does it matter? It's earned 0 interest, but I would have lost money anyways in the bulk of the year. And so I can just pay that back and it's back in my account and I don't lose anything. I don't pay interest, but I had this cushion. So it's a nice design tool right now, which is not normal with hardship distributions. You also have the availability of, and you should do this, reach out to loan participants. If you have a pension plan like that I mentioned and you offer loans, reaching out to those individuals and saying, hey, you know, not only can people take extra loans, normally the maximum is 50,000 or 50% of your balance, whichever is less. But now that max of 50 was increased to 100,000. And so then you pay no tax and you have the option to pay it back if you don't use it. And you defer payments up to a year. So it's another way to pull your money out, sit on the cash and use it as a cushion and then pay back what you don't use. Or pay it back over time through payroll. The other thing I want to mention is for existing loan participants, you want to make sure to reach out to them because they also have the opportunity to defer their payments for a year and then you can re-amortize their payments so they have less withheld out of their check right now. Finally, this 401k provisions, the nice thing about it is you can start operating right away, right? One thing also, you can do a waiver of required minimum distributions, which is nice if you have older employees or participants that, you know, normally have to take money out and they want to give themselves time to recover from the recent losses. They don't have to do those forced distributions. But you can start operating with these provisions right away. And the plan amendments, we got loads of time to work those up retroactively later. I put this example, most of us are on a calendar year plan. The language in the parenthetical is the statute language. But if you're on a calendar year plan, which most of us are, the plan amendment can be done and dated retroactively or implemented retroactively as late as December 31st of 2022. So we got lots of time to write a short amendment to your plan. Lastly, this is a nice tool in your toolkit, and it kind of ties in, you know, at first it was a way to help supplement unemployment, but now I'm seeing the people that are using it are looking because they're essential and they need their people to come in and they could make more than more on unemployment. So one thing to note, this is not payroll. This would be done through like accounts payable. These are not, these payments under 139 are only available for a short-term basis. 139 of the tax code is only in effect when the president has declared and invoked the Stafford Act and declared a national emergency or disaster. So for that reason, you can then use 139 of the tax code. And that means you issue it as a quote unquote reimbursement for expenses related to the disaster. That could be additional commuting expenses. I had a client just who finalized their 139 payments yesterday for existing employees who are coming in. It's nice because since it's not pay, it doesn't go into your regular rate for overtime. And it's also nice for those on unemployment because it doesn't, since it's not payroll, it's not wages reported. The reason it's not nice is if you're getting PPP loan money, this isn't going to count towards one of your quote unquote payroll costs that you need to use your loan money for. But what you do is, I'll give you this example, is that the person I just finished this with yesterday sent out a short memo, that's all that they needed, to their employees to say, look, if you're going to work full time, your full work week, and you're available to do that, we're giving out $200 reimbursement stipends to address additional childcare costs, additional food delivery, the cost of trying to get that food outside of normal hours. You might have to order at different places when, you know, businesses aren't open, to grocery stores are limited hours now, and also to address additional commuting expenses because we don't want you taking public transportation. And so it maximizes what you're giving out because it's tax-free to that individual. So it's more cash in their pockets, and you still get to claim it as a business deduction, and you don't have to go around getting receipts from everybody. It's just a flat amount. So they did 200 for everybody that was full-time, working their full-time schedule, or it was something like, you know, if you work less than full-time, we'll give this out based on, it was like, I don't know, $20 a shift or something. And they broke it out as the stipend for that inconvenience cost to you, because they basically needed to raise people's pay and bump it up $800 a month or so, because if they went on unemployment, they'd be getting more money. And so they were very resentful about having to come into work and risk their lives. And so, you know, it's a nice way to do that without increasing extensive obligations on the employer side and not having payroll taxes and all of that. And there we go. Julie, you want to take it over?
Sure. I think that at this point in time, we can, I think that Jessica is going to jump in to see if there's any questions. I know that I think we had a few pop up. We were kind of trying to address them on the way through. So Jessica, take it away.
Yeah, thank you. Thank you, ladies, for that really good information. That's exactly it. Let's go ahead and transition to Q&A here. Just as a reminder to everybody watching, if you would go ahead and drop any questions you have in that chat box there. We did collect a few questions ahead of time, so we'll go ahead and start with those. And I wanted to also point out, Harriet in here dropped a comment just on the SBA lenders to keep in mind that in addition to the typical SBA lenders in our area, First Secure Community Bank is also taking PPP applications. So if you go on the SBA website, you can see any of those lenders that are available in the area. So one of the questions we got ahead of time is actually more on the individual side, but been hearing some rumors floating around about this, and we've got attorneys on the line, so this is a good opportunity to dispel those. So in reference to the stimulus checks that were part of the CARES Act, can you talk about, are these stimulus checks in advance on Citizens 2020 tax bill?
You mean in advance on refunds due or a reduction on their tax? I'm understanding because taxes due would be, would be a deduction off of what is calculated for income, and a credit would be refundable no matter what. So if it was designed as a credit, then that's something that's a new credit that has nothing to do with the amount of income you receive or phased out. But I don't view this as a advance on anything for 2020 tax bills, because here's why. It was a brand new entitlement that didn't exist before. So whatever you had due or whatever obligations normally existed for 2020, you don't even, I mean, however it's reconciled on the 2020 tax filings is irrelevant, because it's not an advance on a refund you were otherwise due. It's not going to reduce the amount that you would otherwise get refunded to you.
Perfect. Thank you. So on the paid sick leave, so I've got a couple questions that I've gotten ahead of time that you guys did address a little bit here, but we can maybe just kind of re-highlight them. So one of the questions, really the confusion that I've been getting is over the start date on the FFCRA. So as Julie, I believe you said it started April 1st, 2020, and nothing's retroactive. Is that correct?
So for unemployment's retroactive, but for the paid leave, either the 2 weeks to 80 hours or the expanded FMLA up to 10 weeks, that starts April 1 going forward. So if somebody was furloughed, let's say on March 15th, they wouldn't get and they were then on furlough on April 1 and they became ill, they wouldn't get the leave because they were already on furlough and not actively employed during it.
Okay, so a little bit different depending on the provision there.
Yep, unemployment goes backwards, the other ones don't.
Okay. And then with the expanded FMLA that you talked about, how long does that expansion exist for?
So that goes through December 31st of 2020. Unless it is extended later on, but right now it's through December 31st of 2020.
Okay. And one of the ones you guys talked about already as well, we've gotten some questions about if there are exemptions for those employers under 50. So Julie, I don't know if you just want to kind of reiterate if what you said about that was really helpful.
Yeah, so that is really hard. So my best advice for that one is, if you think that you could fall under the exemption, give your friendly labor and employment attorney a call, whether it's us or somebody else, because you really have to go through that. So essentially, you have to establish that by giving individuals the 2 weeks off or giving individuals the 10 weeks off, and remember, you are collecting the credit back for that. By not having them there, it would financially cripple to the point where your business would be shut down. And so it is a really hard bar. And I don't know if I've seen anybody be able to meet that bar yet. Have you, Rebecca?
I have not. And one of the other issues that comes up is, like, I've had the question of, but this is a key person for us, right? They want to use that key employee with if you're a key employee, you're exempt from certain things under FMLA. But really, key employees get FMLA leave. They just don't have the right to reinstatement. They get to continue their benefits. It's unpaid leave, like under the regular statutes. So even in the case, like, I don't know how you'd have, and key employees that are FMLA are usually defined as like the top 10% and, you know, of highly compensated and somebody who is, you know, critical to the organization. And even then the regular FMLA statute says you get 12 weeks. So, I mean, I guess if you have a combination where you're under 50 and it's a key employee, but then even then, you know, really they can't telework at all. I mean, there's no way to minimize the hardship on your business operations. So it's really not a DIY project. You got enough DIY projects during the Rona that you can take up. This is not one of them.
And I haven't seen anybody trying using it for their key employees. They're trying to use it for their manufacturing employees.
I had somebody the other day call because they're like their only IT person, which you need right now, was wanting to just be done. And be out because it was too much to take care of kids, which is hard. And Julie talked about that intermittent available option. So that's one way to compensate.
Yeah.
Those are some great tools to be able to use. I think, so we're right about time here. I'll slide one more in. One of the top comments I've been hearing from employers, especially folks that have part-time employees, is concern over bringing employees back as we start to think about what this will look like in the coming months. I've had employers who have had employees say that, as you commented on, Rebecca, they're currently making more on unemployment than they were potentially working part-time for that employer. So as people start to think about bringing folks back, you gave some really good tips. One of those tools that you talked about for being able to kind of supplement things. One of the questions that we've been getting is, if you offer to bring someone back at their full position, are they still eligible for unemployment, or does that end their eligibility?
Do you want to take this one, Julie?
Sure. I think it would end their eligibility, because if, let's say, somebody is placed on a temporary furlough and then we now have work available for them, then they are no longer, there is work available. So they would no longer meet the classic configuration of eligibility for unemployment. I think that the caveat would be, again, is if we're saying that you could come back to work, we have work available to you, and we aren't producing a safe environment, you know, they have some of the other qualifications, like, well, we have work available for you, but schools are still closed and there is no child care provider. So yes, generally speaking, but in the land of lawyers, everything is gray, including our background. There's always a yes, but type of thing. Like,
well, and like you're saying, Julie, why do they not want to take that offer to come back full time? Is it just because they can make more unemployment? Then yeah, that's a problem. But if it's because they're, you know, high risk and they're not ready to merge back in and they're acting on the advice of a doctor, or all those FFCRA reasons, now you have work available. So now they're possibly triggering eligibility for FFCRA leave. The government has designed all these ways to fund payroll, and it's a matter of what source is it coming from. And another thing that Julie and I have both discussed is, like, it's way too hard. I mean, you get 8 lawyers in a room, you're going to get 8 different opinions. But I know this is one area where Julie and I agree, is that the unemployment rate is going to be insane. I'm in Wisconsin, and 30% of the population is on unemployment right now. So part of your rate that you're taxed as an employer is based on an industry rate and the general health of the trust fund. And you know what? That's going to be maxed out. Like, we're all going to be paying an increased tax rate going forward. I mean, every business is, to fund this current unemployment situation. So I don't think, you know, one claim being a stickler of it is a difference. Instead, focus on the why and ask the questions, and make sure you're exhausting and making sure the employee's on the right track, and not just being, you know, a jerk. But of course, if they're just being an unreasonable jerk, then you can't help them.
I think that a lot of the key right now is to, and I think I said this a couple of times, to take a deep breath. This is changing. This is really fluid. This is really anxiety ridden for you as a business owner or a HR professional, as well as for your employees. And there are different tools in the toolkit and in the toolbox. Like Rebecca said, it's just a matter of weeding it down to figure out which ones we could do, and then working with our employees, because we want to ensure that when we've passed the apex of this crisis, that our good employees we get taken care of, so that we walk that delicate balance so that they come back, and so that we have that comeback. So it's a delicate balance, and and we'll be able to do it. It's just the whole, like, we do this initial, like, knee jerk, but I need to, and it's like, well, let's look at all the different options. Maybe there's a different way that we could do it.
Absolutely. Well, as we wrap up here, we are a few minutes after 3, so just to respect everybody's time, we're going to go ahead and start to wrap up. On the screen is contact information for myself and Colleen here at the Chamber to be able to reach out to. If you have additional questions, we would be happy to try and find those answers for you, point you in a good direction. and use some of the great information we got today, certainly to help you find some of those as well. So thanks so much for those questions, ladies. We really appreciate you being with us.